24-9566, Bonilla-Espinoza versus Bondi. And Mr. Ryan, if you would proceed.
Thank you, Your Honors, and may it please the court. Brendan Ryan on behalf of the petitioner. I would like to ask for 2 minutes for rebuttal if possible. Your Honors, this case concerns a 29-year-old man whom the agency found to be fully credible and who was repeatedly targeted because Salvadoran police falsely labeled him a gang member and imputed to him his mother's anti-police, pro-human rights activism. Over the course of 5 years, he and his family were repeatedly harassed by police, both on the streets and in their store. He was arrested and imprisoned 3 separate times, despite being innocent of all charges. And during each of those detentions, he was beaten, abused, and tortured. And perhaps most importantly, his mother and his sisters have now been disappeared by the Salvadoran government for more than 3 years, and he has no idea whether they are still alive. Yet, despite these unrebutted facts, the agency denied all relief to petitioner on asylum, withholding, and CAT. That was error for at least 3 reasons. First, the agency ignored material evidence supporting his asylum claim based upon political opinion.
How do we know that? Counsel, how do we know they ignored it? Because don't we start with the presumption that they didn't?
So we start with the presumption that they didn't, Your Honor, except when we see no evidence in the actual decision that they considered that evidence, it raises a really important question of whether they did. And
well, how do we square that argument with our authority that says they don't have to write everything down in the decision?
So I think you square that, Your Honor, with the authority from this court's decision in Curiae, which says that when the agency ignores material evidence, that is legal error. And here, Your Honor, there was very important material evidence that was not dealt with at all in either the IJ's decision or in the agency's, the board's decision on appeal. And we believe that
What
yes.
was that material evidence? He had testified that he never said anything at these meetings. He just accompanied his mother. So what is the material evidence that was disregarded?
So 2 categories of material evidence, Your Honor. The first is his evidence that directly ties the police's actions to both his, but I think most importantly, Your Honor, his mother's political activism, including evidence. I'll give you a couple examples. He talked about how his mother was promoter of FESPAD, which was that human rights organization in El Salvador. He explained that the police repeatedly harassed both him and his mother and his family at their store, where his mother displayed, I think quite proudly, her FESPAD diploma. He explained how his mother pushed back against police abuse, telling officers to behave, to respect people's rights. And I think also went into the community and actually defended members of the community when the police were overreaching. And I think the other really important piece of evidence that he gave was when he was arrested in September of 2021, that was his second arrest, his mother came to the scene and advocated for him and told the police to respect his rights. And the police ignored her and then arrested him and told him that he was lucky that she was there. Otherwise, they would have no idea where he was. And so we think that that shows quite persuasively that the police were aware of who his mother was, that she was a community activist, that she defended people in the community. And I think that the evidence shows that they imputed that political opinion, that human rights activism, not only to her, obviously, but also to him. And we think that's
there was other evidence as well, right? Other evidence that would cut the other way and suggest that he was treated this way because of suspected gang membership and that many people in the community were treated the same way as him, which would cut against the idea that this was based on his mother's activism.
There was other evidence, Your Honor. That is correct. This would be a different case, though, if the IJ and the agency had considered the evidence that I just articulated, and also the country conditions.
But that gets us back. How do we know they didn't?
Because they said nothing about it, Your Honor. And we think this was really important evidence for the agency to consider. And I want to just touch briefly on the country conditions evidence that shows that what the police are doing here, it's all pretextual. And we think that's really important too. The evidence shows that when the police in El Salvador want to harass somebody, what they will do is they will charge somebody with something called illicit association. And it's really just a pretext to harass and detain whomever they want. And we think that is exactly what happened here. He testified both in his affidavit and I think at the hearing as well, but that's what the police do. They charge you with illicit association whenever, and I think he used the words, whenever they have nothing else to charge you with. And we think that was very, no, I'm sorry. I
didn't mean to talk over you. Go ahead.
We think that was something that the agency needed to consider. If the agency was going to take the position that the only reason why he was being targeted was because they suspected him of gang affiliation, they needed to deal with the countervailing evidence, which suggested that this was all just a facade. It was all just pretext. And that we think was error and requires remand.
The problem that I have struggled with, Mr. Ryan, and if you could address it both with regard to the perceived membership in a gang and on your first point, the failure to consider his political opinion or political participation in FESPAD, is not only did he fail to timely file a notice of appeal, that even if you were to entertain the notice of appeal, even though it had not been timely filed, my recollection is that he never made any argument, any of the two arguments that you started with. He never argued that there was a failure to consider mixed motive, that perception that he was tied to his mother's integral role in FESPAD, or the perceived gang membership. The IJ determined that, but he never included that, not only in his, not only if you, I mean, even if you disregard the timeliness, it's not in the notice of appeal. Am I incorrect about that?
So his notice of appeal, Your Honor, I think the notice of appeal itself was timely. I think what happened was he tried to file a brief. And to be clear.
Sorry.
Yeah.
Sorry, you're right. He never included the substance of the argument to the BIA, so they never were able to consider it, right?
Yeah, he as I understand it, Your Honor, he filed that brief late, and the agency rejected it and never considered it. But I will note that, first of all, he was pro se when he was doing all of this. He was detained, and he's also not a native English speaker. But relatedly, one of the things that he said in his notice of appeal was that he didn't believe that the IJ had taken his evidence serious. And then he cited a couple different pieces of evidence that he thought were really important, including the fact that he had been arrested multiple times for, I think what he said, no legal reason. And also he testified, he put in the notice of appeal the evidence about how his mother has been detained and disappeared for the last 3 years.
It just seems to me that you're making some interesting arguments and saying that the BIA in particular didn't address these. And boy, that puts a burden on the BIA to take that one paragraph and say, oh, he's arguing this protected activity, this protected status, etc., and you didn't pay attention to it. And the BIA's got to read minds and be very creative in deciding what sort of issues might be encompassed by that notice of appeal. That's an impossible burden for the BIA, isn't it?
I don't think it is, Your Honor. And I think the fact that the BIA then took the time to actually write out a decision, a short one, dictates or, shows that they understood what he was saying, that he was saying that there was evidence taken. Well, I think
we have cases saying if you want to say it's preserved because of what is addressed in the BIA opinion, the BIA opinion does not satisfy the requirements for preservation by the BIA opinion. You agree on that, don't you?
I do, Your Honor. Yeah. Here's I think that there is.
Yeah, I mean, you had some interesting arguments. If they'd been made to the BIA, they'd be things we have to deal with. But to expect the agency to respond to the detailed, well-developed arguments in your brief in response to a one-paragraph notice of appeal is just asking a lot of the agency. I mean,
so, yeah, well, I will note one other thing, Your Honor. The agency could have accepted his actual late filed appeal, and if we had that in the record,
yeah, they could have.
They didn't have to, but they could have. And if we had that in the record, we could have, taken a more serious look at whether he had exhausted those issues. I will note also that the agency addressed each of the issues that we've raised today with regard to asylum, CAT, and due process. And I think there's a well articulated strand of law that says that when you're dealing with a pro se detained prisoner, we liberally construe the things that they file. And I think that also supports a reason why exhaustion has been met here. And so for those reasons, we think that the court ought to consider the arguments that we're making here today. I do want to cover one more or a couple more issues, if I may, Your Honor.
Please.
One of them, I think, really importantly being the fact that we think that the agency committed legal error when it categorically rejected the particular social group individuals perceived to be gang members without performing any of the analysis required by law.
Well, let me ask about that. I want to hear your third also, but that's the one that I thought was particularly difficult to see how the BIA was going to address that and explain its view, because that you just don't see that in the notice of appeal, and I'm not sure you'd see that even in the proceedings before the IJ. But that's, go ahead.
Well, so the issue, Your Honor, there is that when the IJ considered that potential PSG, she just rejected it out of hand. She said, and I think I quote, "It's just not a protected ground," and then said it's consistently held not to be a protected ground for purposes of asylum, and that's just not right. This court's holding an SCBA.
Well, it may be totally wrong, but you have to ask the BIA and tell them, and then they might well have a good reason for rejecting that as a classification that's entitled to protection. But well, go ahead and you're running out of time, and I shouldn't be asking too many questions. What's your third issue?
Well, and so I think you all understand that issue. And then I think the third issue really gets to the CAT point, Your Honor, which is that the agency failed to consider material evidence and also applied incorrect legal standards in connection with that. I'll just note kind of two related points. One, there was a mischaracterization and downplaying of the actual evidence of torture that the petitioner provided. We think in the opinion that the IJ issued and was affirmed by the agency, you can see an escalation in treatment in the type of treatment he was receiving, in the evidence that he provided with regard to past torture, and also country conditions evidence showing that the situation in El Salvador is getting worse, not better. And so if he were to be returned, the possibility of future torture is quite pronounced. And so we think that is also.
So what was, I mean, as I read his testimony before the IJ, I felt like she was trying to get out of him details of what was done to him, and that she received in return answers that were vague and not necessarily responsive. It was inhumane. They tortured me. I mean, what did he testify to? What acts of torture did he testify to? So a few examples, Your Honor. One, he talked about how he was beaten up several times and treated like an animal. Right, but that's vague. They beat me up and treated me like an animal. I think I'm interested in testimony that would be more to the effect of, they repeatedly punched me in the face and blacked both of my eyes and knocked two of my teeth out. And I'm not suggesting that's the proper level of severity, but that would be more of the level of detail, wouldn't it? Yes, and he did provide testimony about during his third detention, he was brutally beaten on both ears such that he has permanent ear damage moving forward. And so that is a more specific example, Your Honor. Okay.
ultimately, we think that between the evidence that he did provide on past torture, plus the country conditions evidence showing an escalatingly worse situation in El Salvador, demonstrates that he is eligible to relief under CAD.
So let me ask you a quick question about that, if Judge Hartz will indulge me.
Sure.
Assume that the prior instances of alleged torture were too vague for us to rely on, and we're just at the one where they said where they caused him hearing damage. Is that one incident by itself under the case law going to be enough to establish that he was tortured and entitled to relief?
I think it could be, Your Honor, enough to create a rebuttable presumption of future torture because of the experience that he had with regard to past torture. And when you couple that with the country conditions evidence showing a situation that is worsening in El Salvador with regards to the treatment of prisoners and the treatment by detained individuals by police, we think that that's sufficient.
Do you have an analogous case that I could look at?
Your Honor, I don't have one off the top of my head, but we'd be happy to provide one to the court.
Okay.
If Your Honor's would like.
I appreciate it. Sorry for running over.
Okay. Thank you, counsel. Mr. Kelch.
Good morning. May it please the court. My name is Gregory Kelch, representing the United States Attorney General. I'll begin by apologizing for any echo you may be hearing. We have several hearings happening this morning, and unfortunately, I could not get one of the preferred rooms.
We're hearing you fine right now.
Oh, that's good to know. Also, I do want to remind the court that there is a companion case that's currently before this court, number 25-9552, BIA's denial of a motion to reopen. And so some of these due process arguments you will be hearing again in that future case. I think I want to begin with a couple of points. And the first I want to make is that immigration court hearings are like other court hearings. They're adversarial in nature. And remember that the Department of Homeland Security also has a right of appeal. It's not the role of an impartial judge to be creating legal theories for the alien, for the unrepresented alien. The judge's role, what judges will typically do, is to help the alien, the pro se alien, present his own claim. And the claims that he presented before the immigration judge were first, political opinion persecution. Well, the problem with his political opinion argument is that his problems with the police began before he and his mother joined FESPAD. He testified that he started having problems with the police in 2017. They would stop him and ask him for information. They would beat him sometimes. One point, they arrested him and held him for 9 months before he was exonerated in court. It was then that he and his mother joined FESPAD. So if he had these problems before he became politically active, it stands to reason that this political activism could not have motivated his mistreatment.
Well, his argument, I would assume his rejoinder would be, well, that's exactly what he means in referring to a mixed motive. He's arguing that there was not only a persecution and potentially torture based on his affiliation with FESPAD, but also because of his perceived gang membership, which preceded his involvement with FESPAD, accompanying his mother.
Well, those are two separate grounds, so let me take them each in turn. First, with political opinion. The immigration judge asked him in court, how did you express your political opinions? And his testimony referred back to his participation in FESPAD, which again began in 2018 after his arrest and detention for 9 months in 2017. Then that brings us next to political social group. Fine, yes, Judge Becker. So that brings us next to particular social group. And as this court is aware, there are a million different ways for one to craft one's particular social group. And how one crafts that group does matter. I think what the immigration judge did here is she took the claim as a whole. She took his claim. What was the gist of his testimony before the court? And the gist of his testimony was that he lived in an area, an impoverished area where you have gang crime on the one hand, gang control on the one hand, and an overzealous, heavy-handed police force on the other. And he was asking if he could get asylum for that fact pattern. The problem was that he testified repeatedly, over and over again, that the police treat everyone in his neighborhood this way. He wasn't being singled out. This is just what they do. They stop people on the streets and ask them for information. And when innocent people don't have the information, then they become beaten and sometimes arrested and charged with collaborating with criminals. And unfortunately, it is my job to remind the court that asylum isn't a catch-all remedy for the hardships that people outside the United States are experiencing. It's a very limited and specific remedy. It has to be taught to have a nexus to a protected ground, like particular social group.
Mr. Kelch, let me probe that just a little bit. You argue, as I understand it, that there's really not that it didn't satisfy the ground for a particular social group because the characteristic was so widespread. The government perceived everyone as gang members, but that's not what the IJ said. The IJ said that not because it was too widespread, it was because perceived gang membership ipso facto cannot be a particularized social group, period, right?
Well, so first of all, what the judge said is technically correct. It's not a protected ground. Protected grounds are race, religion, nationality, membership in a particular social group or political.
Well, yeah, he was saying that it cannot qualify, as I remember it, it cannot qualify as a particularized social group, perceived gang membership, period. Presumably, because if you're a perceived gang membership, that's good, not bad. But obviously, there are some circuits that have said to the contrary, that if a foreign government uses pretext to improperly characterize with a broad brush a whole wide group of people as gang members, that could be a particularized social group. But the IJ decided that sua sponte because Mr. Bonilla hadn't challenged that, but she did decide that, right?
Well, I don't know that she did. So I'm looking at the judge's decision on pages 28 to 29 of the administrative record. And on page 28, she says, first, the court considers on account of a political opinion. And then there's much discussion about political opinion. Then we come to the next page where we have this sentence that you note. And then she ends that sentence after saying it's not a protected ground. This does not support a finding that he suffered, that anything he suffered was on account of any political opinion or imputed political opinion. And then she says, next, the court considers membership in a particular social group. So I'm not quite sure what the immigration judge was getting at quite there. I will say that. But I think that if you continue reading the decision on pages 29 and 30, where she does talk about particular social group, what she's saying is that this is how the police treated everybody in the neighborhood. He's not being singled out and targeted for any particular characteristic. The police are doing this to a very wide swath of the population that unfortunately includes his mothers and others outside of his age group and gender. And I think that's what the immigration judge was getting at. What was the claim that he was presenting to the immigration court? It wasn't an argument about pretext. He also did not define a particular social group. He did not claim imputed gang membership. His claim over and over again was that this is what they're doing to everybody. The heavy-handed police in my neighborhood do this to everybody. And what the immigration judge reasonably held was, well, that does not qualify him for asylum because it's not connected to a protected ground. And I think
counsel, let me break in here and ask you a question. I think you've made that point. Assume for a moment he had raised his hand and said, "Oh, I have a social group, particular social group. Judge, it's that they're imputing that I'm a member of a gang, and that's why I'm being singled out." and the judge says, no such thing, we don't recognize that, thanks, you lose on that, would the judge have been right?
So are you asking about cognizability, or are you asking about nexus? Like, what was the motivation for the police?
I'm asking whether it's cognizable at all.
Okay.
Because she indicated that it wasn't, right?
I'm not quite sure what the immigration judge was saying there, quite frankly, because she ends it with political opinion. I don't know if she just misspoke. She was thinking about opposition to gangs is not a political opinion.
Well, it says imputed gang membership is consistently held not to be a protected ground for purposes of asylum.
Well, it's not a protected ground. I just listed them. There's 5 grounds. We think maybe she's referring to a particular social group, but maybe she's also referring to a political opinion. I recognize the issue is there, but when we go on in the next paragraphs, now there's analysis about what motivated.
Well, regardless of what the IJ said, does it satisfy imputed membership in a gang? Does it satisfy the requirements for a particular social group? Is there an immutable characteristic? Is it something you can look at the person and readily identify, or somehow readily identify the people? Does it fit those requirements?
Respectfully, Judge Hartz, we stand by matter of EAG. I know it's not been well received in the circuit courts of appeal, but we stand by that. Criminal street gangs are not particular social groups.
I'm not talking about that. I'm not talking about gangs being. It's imputed membership in a gang. And is that something you can tell? How do you tell whether someone fits that description? And is that something immutable?
Well, it isn't immutable. Now,
it is what?
It is not immutable, because of course someone can not drop out of the gang. Former gang membership can be immutable, because once you have that label, you never be able to shake it. But no, we don't think that gang membership has an immutable characteristic. On that thinking, the point I wanted to make was the BIA and many courts have recognized that taxi cab drivers are not a cognizable particular social group, because your profession is not immutable. So if taxi cab drivers are not a particular social group, it stands to reason that imputed membership in a group defined as taxi cab drivers would not qualify one for asylum. And by that same thinking, we would say, well, then imputed membership in a group called criminal gangs ought not to qualify one for asylum either. But now at this point, I would bring the court back to the notice of appeal. We're having this conversation because the notice of appeal said the agency didn't take my evidence seriously. You know, I can give you my argument. I hope the court recognizes that the BIA cannot be expected to jump down these rabbit holes when all they were trying to do was just review the decision that the immigration judge gave and find that it was reasonable.
Mr. Kelch, could I probe that just a bit? I'm sensitive to that argument. I think it has a great deal of appeal. I will tell you the question that I struggle with is that he didn't, as I recall, Mr. Ryan may disagree with this, and I may be wrong, that he didn't include that in the notice of appeal. I don't think he included it even in his brief that was not timely filed. And so the BIA could very well have said, as we frequently do, well, Mr. Bonilla has waived any challenge to what the immigration judge said with regard to characterization of perceived gang membership as a particularized social group. But the BIA did not say that. The BIA echoed what the IJ said, as I recall, I could be wrong, that said that perceived gang membership is not a particularized, it does not qualify as a particularized social group. And so it seems that it implicates some of our case law that says even when someone doesn't challenge something, if the adjudicator decides it, well, the adjudicator decide it rather than, so anyway, could you address that?
Well, the problem, as you've also held, is that when you take that concept too far, what you do is you scare the agency away from saying anything in its decisions. Here we have a man who's a pro se alien. As Mr. Ryan noted, English is not his first language. He's representing himself. He filed a notice of appeal. Yeah, the BIA could have written a one paragraph and said, well, hey, this isn't specific enough, and therefore we're just going to dismiss your entire petition. They made an effort. They tried to do the right thing here. They looked at the immigration judge's decision and made a review of it. But does that mean that now we can also fault them because they didn't talk about pretextual arrests? They didn't talk about different particular social groups. And today he's talking about imputed gang membership. It could have been family membership. It could have been membership in FezPad, young men in his neighborhood. You could define these groups a million different ways. It's not reasonable to expect the BIA to go down all those rabbit holes. And if with my 30 seconds remaining, I do want to make clear with regards to cat protection. One, agency reasonably found he can avoid future harm by relocating to another area of El Salvador. He has to show a clear probability of torture, not just a possibility. So that was reasonable. And also, I do want to point out to the court, this was not, what he described was not rise level of torture, but even if it did, there is no presumption of future torture in cat protection law. It's only one factor of many to consider. And with that, I will conclude. Thank you all very much.
Thank you, counsel. I know you wanted to have a couple more minutes. This happens all the time. I'm sure you are aware of that. But I think we got your arguments. And,
I understand, Your Honor. And I appreciate that. Thank you for indulging us. I appreciate it.
Thank you. Cases submitted and counsel are excused. And I think with the push of a button, we'll turn to our next case. Is that right? Okay, I see our returning servant here. So we'll turn to 24-1451, Mukhtar versus Lambrecht. Ms. Chan, you may proceed.
Thank you. Good morning, Your Honors. May it please the court. Catherine Chan on behalf of Mrs. Isa Mukhtar, the appellant. This case asks whether the government can moot out a civil action in the federal court by its sua sponte reopening of the underlying immigration case. At least 8 federal courts in the 2nd, 3rd, 7th, 8th, 9th, 11th, and the DC Circuit have weighed in on this question, and none have found blanket authority for the government to moot out a civil case on its sua sponte action.
Well, was it sua sponte in this case? Isn't that what he sought in court, was to start over again? So what was it? Wasn't the agency just responding to the complaint and said, okay, that's what she wants, we'll give it to her? Explain why this was sua sponte.
Thank you, Your Honor. Ms. Mukhtar asked whether the government had any authority to require of her a physical medical exam. The regulations provide that she does not. The statute provides that she does not. So her question to the district court was whether the government's decision denying her residency, despite 4 approved medical exams that she submitted, was in fact legal error. So the sua sponte action by the government to reopen her case was not what she was looking for. She was looking for the decision to be set aside because the government's requirements in and of themselves were ultra vires.
Did she not? I thought her complaint actually sought that relief, was to have a new hearing, new proceeding. No?
No, Your Honor, she specifically asked for the government's decision to be set aside, and each of her arguments pointed to the statutes and regulations that cited that the government had no authority to request the medical exam in the first place. The government's authority for refugees is only to seek vaccination proof. Refugees are pre-vetted when they enter the United States, so both the regulations and the statutes clarify that their only additional requirement for the medical exam is to prove the vaccination records. She, in fact, submitted 4 full medical exams in addition to the vaccination records, each of which qualified her for a residency, and yet the government requested additional upon additional medical exam, expecting her to prove that she was inadmissible when the government's own medical doctors did not find that inadmissibility.
Counsel, does it matter? Okay, so I'll accept your premise that she was only required to have one exam to be admitted to the country as a refugee. Does it matter that she wasn't seeking to continue her refugee status here? She was asking for legal permanent residence, which is a different category. Does that matter that she's seeking a different status?
Thank you, Your Honor. That does not matter because refugees, when they adjust their status, that date relates back to the date that they entered as a refugee. So they do not fit the same admission question that other permanent residents seeking admission as a permanent resident are. She's admitted already as a refugee, and the residency portion relates back to the admission date when she first entered the country.
Tell me, where would I look to find that authority?
Yes, Your Honor, I will look that up.
Go ahead.
There's a regulation and a statute that relates for adjustment of status for refugees. The regulation is found at 8 CFR 209.1 parentheses small c, close parentheses, and the statute is 8 USC 1159.
Okay, thank you.
Thank you.
May I return to my original question, because your response surprised me. I'm not saying it's wrong, but it surprised me, because apparently in her request for relief, she asked the court to, quote, set aside the defendant's decision on her Form I-485 and direct the defendants to issue a new decision on the application for residency.
Yes, Your Honor, the court is not allowed to make the decision on residency. That decision is reserved to the agency. Therefore, the court's power in this case would have been to tell the agency that their decision on residency was mistaken and to instruct the agency to issue a new decision. And that was what Ms. Mukhtar was seeking. That's what all of the briefing explains in excruciating detail, that the agency had no right to ask her for a medical exam, which they did multiple times. And once they denied her on approved medical exams, it was then doubly outside of its grounds for denying her residency.
Okay. But would you still consider it sua sponte action by the agency to say, okay, we'll reopen and proceed and make a new decision on her application? And they apparently, that was not an insincere thing. They asked her again for records, and she refused to comply with, refused to provide more records. And then the BIA ruled against her. She could have appealed at that point and said, well, you reopened, but you made this, you repeated your mistake. So now I'm entitled to relief. Why would that not have been the way to proceed at this point? What was so terrible about the agency saying, okay, we'll try it again?
A couple of things, Your Honor. The first is that the agency never asked the court if it could reopen the case. None of the federal circuits that have reviewed this have found any sua sponte authority for the government to divest the federal court of its original jurisdiction under the APA to hear the matter. In this case, that is exactly what happened. The agency acted on its own in a sua sponte manner, including requesting the very same things that form the basis of the complaint, whether the agency had any right or authority to even seek that information. Therefore, the concern here, just to clarify, the case never went to the BIA. There was a previous administrative appeal, but it was not.
I'm sorry, yes, I apologize. Yeah.
No worries. I just wanted to make sure the record was clear. We don't have a BIA decision.
Yeah.
But in any case, when the district court failed to review whether or not the government had any authority to request even one medical exam from Ms. Mukhtar, much less 5 as it was seeking in the newly reopened request for evidence, that brought up the question of what was the government's authority on its sua sponte motion to divest the federal court. The regulation that the agency relies upon allows a service officer to reopen a case on its own motion. And the actions of this case essentially demonstrate that the service officer's decision has mooted out the district court's APA jurisdiction. There is simply no authority for that, Your Honor. The district court did not include any argument to state that it would have been in agreement with the motion to reopen, that it allowed the motion to reopen. It, in fact, never even addressed any of those questions. And simply to state, the government never even cited the authority allowing it to reopen cases in its new request for evidence for the 5th time, seeking things that Ms. Mukhtar had already produced, that she was not required by law to produce, and that in our argument to the district court, the government's actions were prima facie outside the bounds of the law.
Let me ask
what are you seeking? Let me ask one question first, Judge Koshin. Well, so what are you seeking? If all this was incorrect, what do you want from this court? A ruling on whether they could reject her on the basis of the medical records she had provided? Is that what you're seeking, or what else? What is it?
That would be very welcome by Ms. Mukhtar, since the facts are already established by both parties. What we think would be more important moving forward in this circuit is for the court to speak directly to the government's authority or lack thereof to sua sponte divest the federal court of valid APA jurisdiction, for which we have cited Relax v. Baran, which has been followed by all the circuits.
Say we do that. Say we do that, okay? You were wrong to do this. Now, how do we dispose of the appeal?
Since the district court never weighed in on any of these legal questions, one manner would be to remand for the district court to weigh the legal questions. And if the court is willing to decide the case on its merits, again, Ms. Mukhtar would welcome that, because both the statute and regulations make absolutely clear that she was not even required to give a medical exam, only vaccination requirements. And for the 4 medical exams she gave, each was approved by a panel physician of the government.
So okay, at the bottom you wanted, the one thing you definitely want, at least as a minimum, is to send back to the district court to have proceedings, but you would welcome, I gather, a decision by this court on the merits of the issue. Is that right?
Yes, Your Honor.
Okay. Sorry, Judge Carson.
Okay. I have a couple of questions, and there's some underlining premises to your argument. And one of them is the idea that once she had the initial examination to be admitted as a refugee into this country, that at that point, there's no authority for the government to ever require her to have another one.
Yes, Your Honor, that is in the statute and the regulation.
Okay. And I will give you that the regulation seems to say something like that. My second question is what if she's admitted and there are some notations in their medical report, and we find out the government finds out once she gets to the country that she has some alarming behavior and maybe her medical conditions have worsened, or that they were worse than originally noted? Would the government be without authority to exclude her on that basis?
Your Honor, is specifically to the facts of this case, where she was found incompetent to proceed in the state court below. The state court below also released her from supervision from the state's mental health care institute. So in other words, the state has found her not to be a danger to society by releasing her from the obligations for inpatient care.
Therefore, no, I'll accept that. I know that that's the fact of one of the facts in the case. I'm just asking, as a general matter, is it your position that the government wouldn't be able to look at that and say, "Whoa, this is concerning. Look what's happened. It looks like her conditions worsened. We either want another examination or we're just going to exclude her outright"?
Your Honor, because both the statute and the regulation speak directly to that, it is our argument that the government cannot override the statute or the regulation on its own hunch, if you will, or premise. And even if the government does...
It's not a hunch or a premise. I mean, they have actual evidence in this case that there are problems here. I mean, they've been dealt with, but the government, I mean, they're not proceeding in bad faith. I mean, there are things that happen.
The things that happened, Your Honor, again, the exclusionary grounds for adjustment of status, she hasn't triggered any on criminal grounds. She hasn't triggered any on medical grounds. Both the statute and regulations say that for refugees who have very specific rules outside of the general population when it comes to adjustment of status for residency are not required to repeat a medical exam.
Okay.
Most refugees do come to the United States with certain pre-existing significant mental health trauma, and that may explain why the statute and the regulation foreclose the second guessing of that, because of the significant vetting that happens before they're admitted as refugees by the United States government, including medical providers for the government.
Okay, I have one more question about the government's ability to require further exams. And that is, I mean, if she provides the government with an exam where the doctor didn't fully fill out a form, or there's something that's clearly erroneous on it, it's internally contradictory or something like that. I mean, is the government required to accept that form just because she got it from their provider?
Your Honor, we cited this fully in the briefing. The government has an internal process where it, not Ms. Mukhtar, is supposed to reach out to its own medical provider and ask for clarification. The government has never once requested that from any of its own providers, and instead attempted to shift the burden to Ms. Mukhtar to provide what the government is seeking, which the government's doctors are not stating. So yes, there is a process for the government to check with their own doctors, which they have failed to do in every instance in this case.
Can I ask one question about an issue that we haven't talked about? The government argues in the alternative that there was not a jurisdiction because there was not a final agency action, and I don't recall seeing anything in your reply brief addressing that. Am I incorrect about that? And in any event, is there a response to the government's argument for lack of jurisdiction, irrespective of mootness?
I request the court's permission to go over my time to respond.
Yes, please. Yes.
Thank you. The finality question is what is baked into the RELEX argument as to when and if the government can sua sponte reopen a case. So our argument is that, number one, the government does not have regulatory authority to override the court's jurisdiction. Second, that the first decision marked was final because the court never allowed the government to reopen it. The court simply accepted that the government had reopened it without any addressing of Ms. Mukhtar's claims as far as the case in chief. So we would count the first decision in July of 2020 as marking the final decision, and the government's subsequent reopening was the exact same matter that we had been litigating with them. Today marks actually 10 years of litigation on the same question.
Thank you, counsel.
Thank you.
Mr. Tucker? You may proceed, Mr. Tucker.
Your Honor, I think I'm proceeding now, if I may. Michael Johnson for the government.
Oh, I'm sorry. What's the... Okay, you're the right person from the picture, but you're labeled as Mr. Tucker on my screen. Maybe I'm misreading something. Yes, Michael Johnson is supposed to be the attorney representing. Can we start again at 15 minutes? I apologize.
Thank you, Your Honor. Good morning, Your Honors. Michael Johnson for the government. This court should affirm because the district court correctly ruled that this matter is moot. This court should also affirm because there's no final agency action in this case, and Ms. Mukhtar has not responded to the government's argument that there is no final agency action, and therefore that issue is waived. This case, as to mootness, Your Honors, this case is really a pleading case. Ms. Mukhtar asked for very specific relief in her complaint. Judge Hartz, you quoted the exact language in the prayer for relief in the petition. This is the only specific relief that Ms. Mukhtar asked for other than attorney's fees. The agency gave her what she asked for. It set aside the July 2020 decision, and it issued a new decision in May of 2024. The purpose of the pleading rules is to give the court and the parties fair notice of the claims, the defenses, and the relief sought. Here, the prayer for relief sought specific, detailed relief. Ms. Mukhtar does not contend that the district court incorrectly construed the prayer for relief. If she had asked for something else or something more or something different, perhaps this would be a different case, but she didn't ask for anything else.
Go ahead, Judge Carson.
I think she does. I think her position today is that the prayer for relief may seem simple, but when it's read as a whole, the petition makes clear that she was seeking more than just a new decision. She had grounds for, and that were alleged in the petition to keep the government from just reopening the case or going back and doing the same thing for an impermissible reason.
She did not ask for that in her prayer for relief. She is the master of her petition for relief, and this is a counseled case. She could have amended her prayer for relief to ask for this specifically when the government notified her that it was reopening the case in October 2023, but she didn't seek to amend her petition for relief. And also, she never asked for amendment to the district court, and on appeal, she hasn't asked that in her briefing that the matter be remanded so that she may have the opportunity to amend her petition.
So what did the district court, does the district court have anything? How did the district court respond when the government said, we'll reopen? Did the district court bless that in any way? Or did it just wait until the government said this should be dismissed as moot? How did the district court respond?
The government filed two motions to dismiss. The matter was reopened in October of 2023, and then the government filed its first motion to dismiss after the initial reopening, and then the district court
as moot. There was a motion to dismiss as moot. Is that right?
Well, the first motion to dismiss that the government was filed as soon as the matter was reopened was a motion to dismiss on the grounds that there was no longer a final agency action. And this was in November of 2023. It's the appendix at pages 73 to 89. The district court did not rule on that motion. And then in May of 2024, the agency issued its new final decision on Ms. Mukhtar's adjustment application and denied the application. The government then filed its second motion to dismiss, arguing mootness, and that is the motion that the district court ruled on. The district court did not, there's nothing indicating the district court's view regarding the reopening other than what is presented in the court order, and this is the appendix at pages 190 to 196, where the district court explains its views regarding the reopening, and it determined that the matter was moot.
So there's no order by the district court blessing the reopening.
The court, by granting the government's motion to dismiss, did bless the reopening.
Yeah. Until then, though, so anytime something's before an agency, your view, I gather, is that the agency could say, okay, this is in court, we'd like to reconsider this. And by doing so, they destroy the finality of their prior decision. And that's something the agency can do without any leave of court. Is that your position?
I'm sorry, without any legal, I didn't hear your last word.
Of court, any leave of court.
Yeah, leave of court was not required here for the government to reopen.
She's saying there's lots of authority from other circuits saying that you do need leave of court to reopen.
That is not true, Your Honor. We cite the Second Circuit's decision, 6801 Realty, in our answer brief, and in that case, the Second Circuit indicated that the agency USCIS may, on its own, reopen a matter, and it did not find any issue with that. There are several other cases that we also can present to the court. Balakirov versus Jadao. It's
rather than your cases, she said she cited cases. Do you distinguish the cases? Maybe they're not in a brief, but she mentioned it in her argument at least. Are you familiar with the cases she's referring to?
Those cases are distinguishable. In those cases, the courts found that the government had failed to follow the process for reopening. The RELAX case, RELX, sets forth a three-part test for reopening. And if that test is met, then the courts have found that reopening is not in name only. But the cases that Ms. Mukhtar was relying on are cases where the courts have found that reopening was in name only. And as we argued in our answer brief, this was not a case where reopening was in name only. First, the agency did follow the applicable regulations in reopening. It served notice of reopening. It gave a period of time to file a response. Secondly, the agency requested new information, and in particularly, third, it offered a reason for reopening, and this is clear from the July 2020 decision that the agency issued, where it explained in great detail the deficiencies with Dr. Shah's I-693 medical examination report. And the agency identified in the October 2023 reopening what Ms. Mukhtar should do to address those deficiencies so that her application could be considered and if proper would be granted.
Let me stop you for a second. Two things with this. And first off is, do you agree that the regs provide a mechanism for the agency to reach out to the doctor to clarify something or to supplement something if their report is insufficient?
Yes. Here, Dr. Shah's report was inconsistent. His report from January 2020 was inconsistent. There were significant inconsistencies. In one sense, the report indicated that Ms. Mukhtar had no Class A or Class B conditions, and then on the very next page of the report, he indicated that she did have. Dr. Shah indicated that she did have Class B conditions.
Okay, let me stop you for a minute. That wasn't my question exactly. My question was, do you have the authority? Does the government have the authority to reach out to the doctor directly and not kick it back to the applicant? You see what I'm talking about? Could
Yes.
the government have just reached out to the doctor and said, hey, there's a lot of problems with this report. We need you to clarify X, Y, and Z and send us a new report. Could the government have done that?
I don't have an answer for that right now, Your Honor. I would be happy to submit a 28J letter to the court as soon as possible and give you an answer. I would need to consult with agency counsel on this particular issue. I don't have an answer right now.
Okay. And my second question has to do with this 8 CFR 209.1. Counsel pointed this out to us, and it is cited in her brief, and it states in section C, a refugee seeking adjustment of status under section 209A of the Act is not required to repeat the medical examination performed under 207.2C unless there were medical grounds of inadmissibility applicable at the time of admission. How does that affect your case?
We submit, Your Honor, that issue has been waived. It was not preserved in the district court. It's not part of Ms. Mukhtar's prayer for relief in her petition. It is not discussed at all in her opposition to the government's first motion to dismiss filed in the district court. she mentions 209.1C only in her conclusion of her opposition to the government's second motion to dismiss, and she didn't properly raise it on appeal here. As for her opening brief, 209.1C is not raised in her argument section. It's referred to in the factual background, but there's no developed argument about section 209.1C in her opening brief. And she cannot raise it for the first time substantively in the argument section of her reply. This court has held numerous times that a party does not preserve an issue merely by presenting it to the district court in a vague and ambiguous manner or by making a fleeting contention before the district court. That's this court's decision, GeoMetWatch Corps versus Human, 38 F 4th 1183 at 1206, 10th Circuit 2022. Similarly, this court in Ray Rumsey Land Company stated that a party cannot preserve an argument for appeal by raising it in the district court in a perfunctory and underdeveloped manner. The site for Rumsey is 944 F 3rd 1259 at page 1271, and that's 10th Circuit 2019. Here, Ms. Mukhtar has raised the issue of section 209.1C in only a fleeting or perfunctory manner. She did not preserve this issue, and therefore this court need not address it.
Mr. Johnson, let me ask you a question. Now you rely heavily, I think, on paragraph 90 of the petition, where she asked for the decision to be set aside, and you say, well, it was set aside, but you're arguing apples and oranges between the two sides. You know, she of course is arguing that, well, it needed to be set aside because the government was asking for improper information. They had no right to ask to submit additional questionnaires, that issue had been determined and needed to issue a new decision without asking for additional medical information. And you argue, obviously, that there was ambiguity in the medical information that was provided. And so then the decision is set aside. Well, why is it moot if it was set aside for reasons that were unrelated to the substance of her argument? That ordinarily your argument would have a lot of appeal, that there's a due decision, that she has a right to challenge that. But in effect, that's the same argument that she had presented all along in this particular case. You know, why is it moot if the agency never addressed the substance of her argument, and she has to simply re-urge the same argument with regard to the new decision?
It's not moot, Your Honor, because the inconsistencies in Dr. Shaw's I-693 from January of 2020 were such that the agency was of the view that if the matter was reopened and those inconsistencies could be addressed, that then the agency could take a fair shot at the application and adjudicate it. But in submitting, in reopening, the agency asked for a new I-693, but Ms. Mukhtar did not provide one. And so then in May of 2024, the agency denied the application after reopening based on the failure to respond to the I-693. Ms. Mukhtar was given 87 days to respond to the to provide an I-693. I apologize, but never provided one.
But if we were to credit her argument that she didn't do anything wrong by not submitting a new report, her whole argument was that she was never obligated to submit that medical information, right?
She had an obligation to demonstrate admissibility to the United States under 8 U.S.C. Section 1159A2. In the agency, in adjudicating an application for adjustment of status of a refugee, it states that the alien, the immigrant must show admissibility at the time of her request for adjustment of status. So the agency was simply following the statute 8 U.S.C. 1159A2. And I note that my time is over, Your Honor.
Go ahead and answer. Just don't wander.
Thank you. If this issue had been properly before the district court, the issue of 8 CFR 209.1C, and Ms. Mukhtar had presented it to the district court, and the district court could have addressed it, this would be a different story. But it was not addressed, and so we submit the issue has been waived, and this court should affirm the decision of the district court, and unless the court has any other questions, I would ask for affirmance.
Thank you, counsel. Thank you both, counsel.
Thank you.
Case is submitted and counsel are excused. And we'll turn to the next case, and maybe I'll get the names of the attorneys right this time. I apologize again, Mr. Johnson.
Thank you.
So our next case is 25-1006, Citizens for Constitutional Integrity versus the United States. Mr. Pettigrew?
Yes, Your Honor.
Did I get the right name? Did I pronounce it anywhere close to right?
That was that was excellent pronunciation. Thank you, Your Honor. Yes.
Okay.
Not common.
Thank you,
Your Honor. May it please the court, my name is Jared Pettigrew, and I represent Citizens for Constitutional Integrity and Southwest Advocates Incorporated. I would like to request 2 minutes for rebuttal. Citizens seek reversal and remand for the district court finally to rule on the merits of their SMACRA, Surface Mining Control and Reclamation Act claims. With the benefit of the clarity provided by this court, citizens amended their complaint to add arbitrary and capricious claims and to refine their citizen suit claims. The district court erroneously dismissed the arbitrary and capricious claims for failure to exhaust administrative remedies. OSMRE, though, held a secret administrative appeals process, and the district court never ruled on citizen suit claims. Once in southwestern Colorado, the King 2 mine had 7 employees and produced about 7,000 tons of coal. GCC bought it, and now it looms over the Hesperus community. It employs 140 people and produces almost 1 million tons of coal every year. GCC consumes water from the La Plata River by spraying it on the coalface during mining to suppress coal dust. GCC bought water rights from a nearby farm, but GCC and OSMRE violated OSMRE's regulations. OSMRE does not know how much groundwater the mine is intercepting. It does not know how much surface water the mine is using, and OSMRE cannot protect the health and safety of the public without that information. So the district court erred by concluding citizens failed to exhaust their administrative remedies. OSMRE held a secret administrative appeals process and thwarted citizens from participating. 5 times, citizens requested OSMRE to send them a copy of the permit approval.
First 4 times there had been no approval, right?
For the first 3 times?
The first 4 times.
I think only 2 or 3 times, Your Honor. We requested one during the permit approval, and we requested one after. I have those on. I have the timeline right here on page 25 of my brief. So, 2 requests before the approval, and then 3 after. 1 during the administrative appeals process, and then 2 after.
Okay.
Thank you, Your Honor. So citizens did not, OSMRE did not give that document to citizens until 11 months after the administrative appeal period closed. So the law does not require exhaustion of unavailable processes. The district court first misapprehended the order of events. Second, it failed to require OSMRE to prove its affirmative defense. And third, Section 1264 gave citizens a right to bring their claim directly in court. So on the order of events, the district court found citizens received notice of the permit approval. It's wrong on the timing. DOJ sent the wrong document and sent it too late. It sent the Mineral Leasing Act plan approval, but citizens sought the SMACRA permit approval. And DOJ sent that 3 weeks after the appeal period had already closed. OSMRE does not dispute that citizens had no notice in time to participate in the administrative appeal. Second, on the lack of notice, the district court flipped the burden of proof to require citizens to prove that they did not receive notice in time. But the exhaustion of administrative remedies is an affirmative defense. So OSMRE bore the burden of establishing the administrative process was available, failed to carry its burden, failed to prove it provided notice on time to allow citizens to administratively appeal. And it does not dispute that here. Southwest Advocates, in the meantime, made comments during the scoping period, during the comment period on the draft environmental assessment to both OSMRE and the Bureau of Land Management. They commissioned expert reports on water and noise impacts. They participated in the La Plata County.
All in the comments to the environmental assessment, right?
Yes, Your Honor. They've sent, all of this is on that docket number. Yes, sir.
And where in the comments to the environmental, where in those comments did citizens or Southwest ever say that the permit for the OSMRE for GCC should be denied?
Well, Your Honor, I don't know if I think they literally said that. I don't have that at my fingertips.
Well,
but
they may have. I didn't see it, and I don't remember you addressing that in your briefing. But I may have overlooked it. But you're representing that they did in the comments specifically ask for the denial of a permit.
I believe so, Your Honor. Yes, I believe I can provide particular citations after the argument. I believe they're at app 171 to 173. That's my recollection, and I'll provide Your Honors with citations. But they objected, and just to be clear, OSMRE treats comments and objections as the same, since it could be difficult to differentiate.
Yeah, but what I'm trying to get at, Mr. Pettigrew, is the document is not an application for a permit. It's a document that's called an environmental assessment. And the comments were critical of the environmental assessment and arguing that there was a significant, that there needed to be an environmental impact statement, not an environmental assessment. But that is a different regulatory requirement than it is for the grant of a permit to a specific entity, GCC. Those were two. Environmental assessment was different from the application for a permit. That's what I'm trying to get at.
Yes, Your Honor. All of those, Congress intended NEPA in particular to be part of the decision-making process for agencies everywhere. That is why it wrote NEPA. And so if you look at the EA itself, if you look at the bottom, it specifically mentions the docket number for this permit. And it says Dunn Ranch Coal Lease by application COC 78825. And so that is, the EA and the NEPA process are part of that administrative process for determining that approval.
I understand that.
So, of course, Your Honor, because the citizens never received notice of the administrative appeal, and because OSMRE didn't prove that notice, they lose. The party who bears the burden of proof loses if the record is inconclusive on the critical point. So OSMRE loses on its administrative, is affirmative defense of the failure to exhaust. And that would require the court to reach the merits of these claims. The SMACRA's text also allows citizens to bring their claim directly in court. Section 1264 gives them a right because OSMRE failed to provide timely notice. And at bottom, due process prohibits OSMRE from holding a secret administrative appeal, giving no notice, and precluding lawsuits when citizens do not participate in the secret appeal. For those reasons, the district court's error requires remand to rule on the merits. The district court also erred by dismissing citizen suit claims. The district court misunderstood its assignment, never interpreted or applied the SMACRA provisions on which citizens relied for their citizen suit claims. It held that the court was bound by the rulings of the 10th Circuit, and it was referencing Citizens 1, written by Your Honor, Judge Hartz, but appellate rulings on motions for preliminary relief do not bind lower courts. And that fundamental error led the district court to hold wrongly that that the 10th Circuit has specifically rejected the arguments that plaintiffs make. That cannot be true. We amended our complaint after Citizens 1 came out. We added new provisions from SMACRA, and those are the ones that we briefed and on which we sought relief. So the district court—
It's true for two of the three provisions you rely on, 1268 and 1271. I don't recall you amending to add 1211. 1211 was always in the case, right? And
yes, that's—
And so, so your argument applies to 1268 and 1271, but would you acknowledge that the reliance on section 1211 can't be considered because that was in the case prior to Judge Hartz's prior panel opinion?
Well, Your Honor, I agree that was in our complaint. Judge Hartz's opinion didn't address 1211. So on the substance of the opinion, it says that we are addressing these provisions. It didn't address 1211. And that was in part because we didn't argue it at that point, and we brought it forth in briefing later. But at bottom—
But you certainly could have argued it.
We could have, Your Honor. At some level, regardless of all of that, the Citizens 1 case is only on the likelihood of success on the merits.
Sure.
So the district court still has to address the claims that we've made. And that is why we're seeking here mainly for remand. We think the district court didn't address the merits of our arbitrary and capricious claims. It didn't address the merits of our citizen suit claims. And this court has held that when it identifies legal error, it remands to the district court to apply the legal standards to the facts of the case in the first instance. And that's consistent with what Congress assigned, and it assigned the district court to make those rulings first. So here we're mainly seeking remand. But even if this court addresses the merits, it would conclude that OSMRE arbitrarily and capriciously approved the permit because it lacked groundwater baseline information and miscalculated the surface water usage. So
you're talking about your 1276 claim. Okay.
Correct.
Before you go back to the 1276 claim from the citizen suit provision, on the citizen suit provision, do you agree that we can only consider your argument for violation of non-discretionary duties if we consider the notice of intent to sue as a demand that OSMRE comply with its unambiguous duties under 1211, 1268, and 1271?
Well, Your Honor, we provided the facts.
Mandamus, you have to say, agency, I want you to do what you're required to do, a non-discretionary duty, right?
Well, we did not have to identify the statutes. We identified the basis and the factual substance, and that is enough.
And the notice of intent to sue relies only on the stream protection rule, right? The notice of intent to sue, I never see anything, even regarding this, certainly never a citation to 1211, 1268, or 1271, nor do I see anything about the substance of it. I do see a lot of discussion about the stream protection rule, which is no longer in the case. So why did you provide adequate notice to trigger the duty to comply with its non-discretionary duties under these three provisions?
Yes, Your Honor, we went beyond the stream protection rule for parts C and D of the 60-day notice, and that's where we talked about, we objected to groundwater notice and diversions of groundwater and groundwater monitoring, and we made specific references to this OSMRE's approval of the diversion of the water.
For
And those are
1258?
we didn't mention the statutes in particular.
No, but that's what you're referring to?
Yes. And I think 1271A is really, I'd like to reserve a little time for rebuttal, but 1271A presents our best citizen suit claim. And that's because it requires an inspection upon someone giving OSMRE a reason to believe that there is a SMACRA violation. And our 60-day notice gave OSMRE that reason to believe. That is an objective determination whether you have a reason to believe. If it's frivolous, of course, that's not enough. But as long as it provides some evidence, that requires an inspection. I'd like to save the rest of my time for rebuttal.
Thank you.
Thank you.
Now we're ready to hear from Mr. Torstensen.
Mr. Torstensen, thank you.
Torstensen, okay.
Good morning. May it please the court, Peter Torstensen for the federal defendants. This court should reject this attempt by appellants, or citizens for short, to revive its shape-shifting challenge to GCC Energy's permit revision application for the Dunn Ranch expansion. After this court denied citizens' request for preliminary injunction in Citizens 1, finding that the agency had carried out all the duties required by SMACRA, citizens amended its complaint to add claims that it concedes are the same claims based on the same facts. But the statutory provisions citizens relies on now are an even worse fit than the ones they relied on in Citizens 1. This court should affirm the district court for two reasons. First, citizens failed to exhaust administrative remedies as required to bring a claim under Section 1276A2. Even if the court excuses citizens' failure, its claims fail because the agency reasonably concluded that GCC's proposed operations will prevent material damage to the hydrologic balance. Second, citizens' pre-suit notice was defective and failed to identify a violation that could compel the agency to bring an enforcement action under SMACRA's citizen suit provisions. Starting with the failure to exhaust. In Citizens 1, this court said that citizens likely did not bring a claim to review the agency's discretionary decisions because it failed to comply with the prerequisites to filing suit under 1276A2. It was right. Citizens does not seriously contest that it failed to request a formal hearing under Section 1264C after participating as an objector in the permit review process. Instead, it argues that it is excused from compliance because it didn't receive direct notice and it engaged with the agency in other ways.
So are you contending they had actual notice?
They in the notice of intent to sue, which is at I believe it's at 1 app 15 or 17 to 22, they indicate that they had received the mining plan approval document and within that the permit approval decision. So they did, at least by January of 2021, have actual notice of the permit decision.
But they had 30, and I think that's consistent with counsel's timeline in his brief. But they had 30 days under your rule, but your position is you had no duty to provide them notice. And I'm just wondering, I mean, how can they ever exhaust if you don't have a duty to notify them and they didn't, and the record's unclear as to when they had actual notice?
So they do have a duty to exhaust, and obviously the timeline kicks in for 30 days from the point.
How can they exhaust within 30 days if there's no evidence they had notice of the permit approval?
Well, there's evidence that they had actual notice of the permit approval, and as the timeline lays out in the record, it is true that they received that after the 30 days would have run. But the answer there is seeking to excuse the delay on the fact that they did not receive the actual notice until after the 30-day period elapsed. But I don't think the answer is to sidestep that the effort to pursue administrative remedies entirely.
So what's your authority for that? That when somebody has a duty to exhaust, but they don't receive actual notice within the time to exhaust, that they must then seek to file something out of time.
Well, I think it's important here to note that the citizens never took steps to participate in the process, either by requesting an informal conference under Section 1264 or 63B, or commenting on the applications that would have entitled it to direct notice of the permit decision. So because they weren't entitled to direct notice of the permit decision, the fact that they did not receive it within the time doesn't excuse them of their obligation to comply with the statutory timeline.
If they had commented on the permit application, then you would have had an obligation to notify them promptly within the 30-day period, correct?
Correct. Yes.
Why doesn't the environmental assessment, in effect, the comments in response to the environmental assessment, in effect, constitute comments proposing denial of GCC's application? Because on the very first page, page 101, the environmental assessment says that it analyzes the effect of, quote, permit revision to GCCE's approved mining plan for underground mining and the new proposed federal lease. They do comment, I don't think that's a dispute, objecting to the environmental assessment. So why, in light of the whole purpose of the environmental assessment on the very first page, why doesn't that constitute a comment that would have required prompt notice of the permit?
Well, I think the requirements for prompt notice would be tied to their participating in the procedures outlined in Section 1263 and 1264. I think whether or not you could treat comments in a separate proceeding, in particular instances, would be a question to raise, when they pursued the administrative remedies, pursued that process, asked for an informal conference and explained that they qualify, to receive direct notice because they had participated in this related proceeding, but one that was distinct. I think that
I'm sorry to talk over you, but and tell me if but I just think I think maybe my question was inartful. I'm asking why the comment to the environmental assessment didn't trigger your obligation to notify them. His response is, well, he can't ask for an informal conference or file some other objection if you haven't provided any other any notification that the permit for GCC has been approved. That's really what I'm trying to ask.
Well, I would say as to that, they do receive notice that the permit revision was under consideration, and referred to his or to council's discussions with the agency in April of 2020, in September of 2020, in November of 2020. There's correspondence, and this is at volume 6, app 117 through 123. There's correspondence with the agency about the permit revision application process. And so he was clearly on notice that there was this permit revision process underway, and they could have very easily requested the informal conference under Section 1263B, and that would have again entitled them to direct notice. It didn't need to wait for the actual approval to request that informal conference. Then
why would they need to ask for an informal conference if the comments regarding the environmental assessment that involved related comments for permit approval? Why would they need to? It seems like belts and suspenders. Why would they need to ask for an informal conference if they've already triggered OSMRE's duty to notify them of the permit approval?
Well, I don't believe that comments in a separate environmental assessment would automatically, under the statute, trigger the obligation for direct notice. I do agree that you could, the agency could consider whether or not this the comments in an alternative procedure were relevant or were focused enough, or I guess it would have excused their duty for kind of formal compliance under section 1263A. But again, 1263A and 1263B are designed to provide the opportunity to comment on the permit revision application and to get additional information and to initiate the procedure or the administrative process. And it would have provided them with the direct notice they claim that they failed to receive. And then I think just to kind of close the loop on council's communications with agency, the December and January communications do not request any information relating to the permit revision. They request information relating to the mining plan approval document, which is again a separate approval that was considered. And so when they received the documents from the DOJ, those were in response to the request for the mining plan approval, and those are the documents that they received, even though at one point in time they were seeking information about the permit revision approval.
One argument made by opposing counsel was that you're trying to switch the burden of persuasion on the exhaustion issue, that there's might be some gaps in the record, but to the extent they're not filled, that's your problem, not his. How do you respond to that?
I would say that there are no relevant facts in dispute. This court would need to decide to determine whether or not the administrative process was complied with. I think the question about whether or not the failure to exhaust can be excused in this particular instance would have been a question that the agency could have addressed, that the district court could have considered in the first instance after the agency had an opportunity to address, and this court would then have a basis for title to direct notice. They did not seek either within the 30-day period or outside of the 30-day period a formal hearing under section 1264C. They simply claimed that they were excused from that because the lack of formal notice, which again, we say that they were not entitled to, and because they participated in related but distinct proceedings. I don't think that those satisfy, or I don't think that's a basis for saying that they exhausted administrative remedies. It could be a basis for excusing noncompliance.
But you are saying that they had the burden on that issue, the burden of whether there's an excuse for failure to exhaust. You're saying is a citizen's burden to establish, as opposed to your having a burden to rebut that. Am I correct?
Yeah, I think that's right.
Maybe we'll hear later, but I think that's the nature of citizens' argument on this, but I'm probably missing something. Go ahead.
And I'll just briefly turn to the citizen suit argument. So we again think that the notice was defective. The citizen suit requires 60-day suit pre-notice. It requires notice of the provision that was allegedly violated and sufficient information to identify the act or omission that constitutes the violation. Citizens 2021 notice of intent to sue did not claim that they failed to take enforcement action under 1268 or 1271. Instead, they argued that the Dunn Ranch approval violated the stream protection rule, which they themselves described as a fundamentally different regulatory regime. The guiding principle with the notice requirements is that it must give the alleged violator an opportunity to bring itself into compliance, and it must give them information about the specific violation alleged. It may not need to provide precise statutory citations, but at the very least, it needs to give them enough notice to correct their instance. And we don't believe that the notice here satisfied that standard. But even if it did suffice, in Citizens 1, this court explained that a citizen suit provision operates only where the agency has essentially no choice. It can't be used to compel even partially discretionary decisions. And here, the statutory provision that they rely on, section 1271A, requires a reason to believe that a violation exists And that determination is at least a partially discretionary determination by the agency. And the agency never made that finding here. I see that my time is about to expire, but if there are no more questions, we will rest.
Judge Hartz, would you accommodate one question?
Oh, I guess so. Will you accommodate his getting a chance to answer your question?
Of course.
Okay.
Counsel, let's assume for purposes of argument here that you are correct that the notice is insufficient insofar as any argument with respect to 1211, 1268, or 1271. What would your position be? What's left of this case if that is correct?
If that is correct, I believe there's nothing left of the case. I think that they failed to exhaust the ability to pursue their discretionary decision claims, and the only thing that would arguably be left would be non-discretionary claims that the citizen suit provision provides for. But I don't think that they provided the adequate notice for that. So this court should affirm.
Thank you, counsel. Mr. Pettigrew.
Thank you, Your Honor. Just some brief points. We heard a lot about Section 1263. That process was never available here because the objection period closed in March 2018, and that's on page 8 of our brief. And we didn't see the environmental assessment until July 2019. So what counsel is trying to do is create an impermeable process that no one can ever challenge. Section 1263 doesn't allow that. Also, the citation, when it says that our request wasn't sufficient, the regulation by the Department of the Interior says it would promptly respond to an informal oral or written request for the date when the applicant received the decision. And that's on page 11 of, I believe it's our reply. So that's sufficient of a request.
Thank you, counsel.
Thank you, Your Honor.
Counsel excused, case is submitted. The court will be in recess until 10:50 a.m. Mountain Standard Time, 10-minute break.
Mr. Pettigrew, I am intrigued by that argument in your reply. My only question is, and I'm not suggesting it is or isn't fatal, but did you present that, did you preserve that argument?
I'm sorry, Your Honor, which argument?
The argument in the reply, I think on page 11, that the Interior Department committed itself to promptly respond to informal requests. That was in your reply. But so your adversary never got a chance to respond to that. So I'm just asking, was that preserved?
Well, we believe we were responding to their argument. We think that we raised the issue of notice early and we just identified an additional authority.
Okay. Okay, thank you. Thanks, Jim.
Thank you, Your Honor.
Shall I try again? And excuse counsel. Case is submitted and we'll still be back at 10:50 a.m. To start, on this end anyway.
Same here.
All right, let me bring them in. Oh, they've got their cameras. The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Thank you. Mr. Tucker, you're muted, but I guess that's probably good for right now. We'll now hear our last oral argument of the day, 25-2016, Ortiz Pino versus Oliver. Mr. Baca.
Yes, Your Honor. Thank you. Philip Baca on behalf of the good Senator Jerry Ortiz Pino. In Holmans versus City of Albuquerque, this court stated, Buckley versus Valio concluded with a broad holding that government does not have the right to pass judgment on how or why a person expends campaign resources. That broad holding is the cornerstone of this appeal. And that's because contrary to Holmans, the district court and the Secretary of State, contrary to Holmans, assert that the Secretary of State has the right to pick and choose which charitable campaign expenditures are protected by the First Amendment. And more precisely, the decision below expressly stated that Section 1-19-29.1A4 does not restrict speech due exclusively to the Secretary of State's promise to, as she put it, consider any funds spent for the purpose of conveying the political viewpoints of a candidate to be permissible expenditures of the campaign. And as an example of this, the Secretary of State reassured the district court, and the district court accepted his reassurance, that a charitable campaign expenditure to a young woman seeking an abortion would be protected by the First Amendment and would therefore be a permissible campaign expenditure. And yet at no time, either in the district court opinion, either by the Secretary of State below or here on appeal, at no time has either the district court or the Secretary of State explained, well, what about Senator Ortiz Pino's charitable campaign expenditure to a young girl seeking to be a prosecutor? Why is that not protected by the First Amendment?
How is that speech? What's the speech?
The speech is, I support a young woman seeking a public service career as a prosecutor. That's the speech.
What if the senator wanted to give $200 to a spouse and just hand it to him? What would the speech be there?
There is no speech there.
Right.
Okay. That's because that is money given to oneself. And okay. The U.S. Supreme Court decided that, held that in Brown versus, district court, O'Donnell versus FEC is that district court opinion on that case. If you're giving money to yourself, that's not a speech.
Okay, so fair enough. So you would agree, wouldn't you, that the Secretary or the Secretary of State has to have some role in determining whether something is speech or not speech under the statute?
No, that's not delegated. That is entirely self-delegated.
How could it ever be regulated?
It could be regulated.
She has to regulate the expenditures.
Yes, and she has to regulate the expenditures based on neutral criteria. That's what the U.S. Supreme Court has said. There have to be criteria in the statute. So she just can't exercise unbridled discrimination, unbridled discretion to decide what is and what is not speech.
But I guess, go ahead.
Yes.
Well, can I ask a follow-up question, sure. Judge Carson? So what if he didn't give $200 to his spouse, but perhaps the young girl was a neighbor and lost a friend at school who was destitute and couldn't afford the funeral, and donated the campaign resources to the girl in order to give to her friend to pay for the funeral expenses. Would that be protected speech?
Yes, and in fact, here in New Mexico, you frequently see people, groups of people collecting money for funerals. And in fact, there have been scandalous killings here in New Mexico in which the victims are unable to afford a funeral, so money's been collected. And so, yes, a campaign contribution to those would be First Amendment speech.
Or so you mentioned one instance. I'm sorry. Did somebody?
No, please go ahead.
So you mentioned so far 2 instances that would be covered by the statute that would be protected speech. That one in the first example. The example that Judge Carson gave would be covered by the statute, but would not be protected. So I take it that there are instances that would be captured by the statute that would involve protected speech, and some examples that would not be protected speech. Is that fair?
Yes, but the statute, I mean, keep in mind, the statute doesn't state that. The statute is very broad. I mean, if the legislature wants to make these exceptions and clarify, just as the federal government has done, and just as other states have done, as noted in the Amicus brief, that has to be done by the legislature.
I understand.
The exceptions have to be carved out.
Yeah.
Yes, and so that's the problem with the statute.
Well, that may be a problem with the statute, but as I understand it, that the statute covers both protected speech and unprotected acts, correct?
No, the only
you mentioned one that Judge Carson mentioned, and you said that's not speech.
That is not speech, and there's a case law on that giving money to yourself is not speech.
But that's covered by the statute, correct?
You cannot donate to individuals. That's correct. So there is an overlap there. So
if the statute covers both protected speech and unprotected acts, the example that Judge Carson gave, that might support an as-applied challenge, but that's pending. That's not before us. Why isn't it preclusive of a facial attack if the statute covers both protected speech and unprotected acts?
Because under FEC versus Cruz and under Homans and under Republican Party versus King, there has to be a showing that the legislature was concerned about quid pro quo corruption. There has to be evidence of that. It just can't be conjecture that that's a problem. There actually has to be a problem, a documented problem. And the statute has to be narrowly tailored. And that's the fundamental problem here, is the statute is not narrowly tailored. It has to be narrowly tailored.
Let me back up a little bit. There's speech and then there's speech. It matters what sort of speech we're talking about.
Yes.
And in Homans, it wasn't you can't spend your money for this purpose or that purpose. It was an overall cap on how much you could spend. Am I correct about that?
Yes, that's absolutely correct.
So it's a little different context, but the Supreme Court has treated contributions as having some First Amendment protection of speech, but not that much. Let me read you from Federal Election Commission versus Beaumont. This is a 2003 opinion. And there they were talking about restrictions on political contributions, which are probably as much speech as you get. And the court said, let me see. Said the petitioner argues that application of the ban on its contributions should be subject to a strict level of scrutiny on the ground that the statute does not merely limit contributions, but bans them on the basis of their source. This argument, however, overlooks the basic premise we have followed in setting First Amendment standards for reviewing political financial restrictions. The level of scrutiny is based on the importance of the, quote, political activity at issue to effective speech or political association. Then it turns specifically to political contributions. Restrictions on political contributions have been treated as merely marginal speech restrictions, subject to relatively complacent review under the First Amendment, because contributions lie closer to the edges than to the core of political expression. while contributions may result in political expression if spent by a candidate or an association, the transformation of contributions into political debate involves speech by someone other than the contributor. And this is the core thing, and this is, I think, the key to how we have to analyze this. What is the standard of review? It says this is the reason that instead of requiring contribution regulations to be narrowly tailored to serve a compelling governmental interest, a contribution limit involving significant interference with associational rights passes muster if it satisfies the lesser demand of being closely drawn to match a sufficiently important interest. And it seems to me that that reasoning would apply just as much to a contribution made by a political committee as a contribution to a political committee. So,
No,
would you respond to that? Yeah.
Yes. First of all, this was never asserted by the district court in the decision below. But secondly, and most significantly, this is not a contribution. This is an expenditure by the candidate.
No,
it is not the same
as a contribution. No, you're talking about an expenditure to a young girl who wants to go to law school. That's the expressive content of that is very limited. And the restriction on expression is very limited. Mr. Ortiz, Senator Ortiz Pino could say, I'm very much in favor of this woman going to college and I would like other people to contribute. He can say all that. He's not restricted from saying that. The fact that he gives her some money himself does have an expressive component to it, but it's not much according to the analysis in the Beaumont case. And that's why the standard of review isn't as strict as you're saying. It seems to me. I realize that Beaumont was not cited by the parties, but we've got to decide, and I think it's a very fundamental part of this issue, what is the standard of review we're supposed to apply here? And as I read that, it's saying that the fact that you spent money, gave money to someone, is not its expression, or can be, but it's not much, because it doesn't really keep you from speaking your mind about whatever you want.
Except that all of the cases that have addressed this issue, charitable campaign expenditures, like for example the Eighth Circuit in the Florida case, they applied exacting scrutiny. They treat all of these as expenditure cases, not under the contribution analysis. The same thing with the cases of giving money to people waiting in line. Those have all been analyzed under exacting scrutiny. So nobody is saying that this is a contribution. And look at Cornelius versus NAACP.
That was solicitations by charitable.
Yes,
and that's clearly speech. That's clearly speech. When you're seeking, if this student was seeking contributions from the campaign, that's speech. That's clearly speech. Making a contribution is much less so. Pardon?
But the Supreme Court in Cornelius did not make that distinction. They said specifically that responding to that speech is also protected speech, and so they didn't diminish that. That some speech is less than other speech. That they put that on the same order. Cornelius was not an expenditure case, but they did address that. Responding to that solicitation is protected speech, First Amendment protected speech.
Let me address the second component, and I have a hunch we're going to go over your time. Don't worry too much about that. These are important and I think difficult issues to address. You seem to say that the only justification for these restrictions is the potential for corruption. And
that's correct.
The amicus brief suggests otherwise, and I thought it made some decent points, and I'd like to expand upon that. Here you have money that you could say is held in trust by the campaign committee or by the candidate. Someone has contributed to your campaign. And what the statute does is say, you hold this, I think in effect what it's saying is, you hold this money in trust and you can spend it for these things. And one is for campaign purposes. Another is if the candidate is a public official, there may be expenses incurred by the public official that can be reimbursed. And you can give money to the state coffers. If you have some money left over, you can give it to the general fund. You can repay it to the contributors pro rata, and kind of a CPRE provision. If nothing else is available, you can give it to a charity, to a 501c3 charity. And is that not a strong public interest in saying that if someone has money contributed to the campaign, then the state can say, we're going to enforce the understanding of the contributor about how that money can be used? Is that not a significant interest?
This is not the state's money. But you're right, it's held in trust for the people who donated the money. But it's the First Amendment that governs. For example, the distinction between a 501c3 and say a 50c4, for example, that's content discrimination. That is clear content discrimination. The state can't say, well, you can give to Planned Parenthood's 501c3 organization, but you can't give to Planned Parenthood's 50c4, which engages in advocacy. You cannot donate to that. That's content discrimination.
Well, does that mean, can the state not at all regulate the use of campaign money based on the legislature's understanding of what a contributor would expect to be done with the money? Is that
this is all
an important interest?
No, this is governed purely by the First Amendment. Campaign expenditures, and the statute refers to these as expenditures. These expenditures are governed by the First Amendment. The First Amendment tells the states what limited authority they have. They are not free to decide based on public interest. There has to be quid pro to regulate campaign expenditure. There has to be quid pro quo corruption. There has to be evidence of that. It cannot be conjecture. And there can be content discrimination. It's not up for the state or the Secretary of State to pick and choose. That's viewpoint discrimination. When you get down to that level, how come the Secretary of State and the District Court have never explained why Senator Ortiz Pino's contribution is not protected by the First Amendment? There's never been any explanation for that. That's viewpoint discrimination when you're making those kinds of distinctions. And the Supreme Court has said so.
Do the other members of the panel have any questions? Yeah, Judge Baker.
I do, if you don't mind. I just want to follow up. You do rely, as I understand it today, and certainly in your briefing, on strict scrutiny predicated on content-based discrimination. You haven't made an alternative argument for intermediate scrutiny, which is your prerogative as the appellant. If we decide, as the Supreme Court did in TikTok versus Garland, that it wasn't content-based discrimination, do we affirm? We don't have, theoretically, there could be an appeal in which we have alternative briefing on intermediate scrutiny, but we would be venturing on our own without the input of anything. So if we do, I understand you want us to say that it is content-based, and you make a strong argument to that regard. But if it's not content-based discrimination, do we affirm?
No, you can remand for the court to consider an alternative level of scrutiny. But, keep in mind, the district court originally applied strict scrutiny when she granted the preliminary injunction. She saw this as a standard campaign finance case involving campaign expenditures. That's how it was originally viewed. And it wasn't until the Secretary of State promised to view a campaign expenditure to a woman seeking abortion as protected speech. It wasn't until then that the district court changed.
And why? Can I ask? Just
sure.
If I ask a second.
Sure. Go ahead.
So why is give me your best argument for why it is content-based discrimination under A4 when it seems to me that you're talking about the mechanism for to take your point, an expenditure of the campaign. You know, if there was a donation to you know, to an individual that's not a 501c3 entity, to let's say for an abortion fundraiser, then that presumably would be under A1. That would be an expenditure of the campaign. If there's a donation to a 501c3 entity that funds young kids going, you know, to pre-law, and they didn't donate to this young lady, and the senator's donation to this young lady for the $200 doesn't count. Why isn't it a reasonable view to say it's not because of animosity to pre-law kids? It's just it's just a, you know, a preference for you know, for giving an exception to under 501c3, because, to take Judge Carson's original point, 501c3 has a tax rule that specifically prescribes self-dealing, which is not true for this particular expenditure. So why is this content-based as opposed to just a reasonable difference in the protections that are afforded to 501c3 entities and just individuals that don't have those safeguards under the tax code and the associated rules?
I'm sorry, are you saying why is a donation
why is this content based as opposed to based on a difference in the protections that are afforded to 501c3 entities versus others recipients of expenditures?
Well, why is there? Well, and let me be clear on this point. Senator Ortiz Pino in the record below testified that he has given campaign contributions to 504 organizations, and he wants to after this litigation.
Yeah, I'm not talking about justiciability. I'm talking about on the merits. Why is this content based when there are specific safeguards under 501c3 in the tax rules that are not available to non-501c3 entities like 501c4 entities?
But why? See, and here's a perfect example. The safeguards in the 50C3 are purely tax-based. The federal and the Supreme Court has held this in Regan. The legislature has decided to give tax subsidies to people who give to 50C3. So that's why there's protections there, and there's limitations on what a 50C3 can do. They cannot lobby the legislature, for example. A 50C4 can. A 50C4 can engage in advocacy. So, for example, there was a ballot question here in Albuquerque on late-term abortion. The 50C4 of Planned Parenthood got involved in that. Now, if Senator Ortiz Pino makes a contribution to that, and we have a different Secretary of State who decides, no, I don't think that's protected speech. Therein lies the problem with the unbridled discrimination. Who is making that determination? It's not in the statute. The statute doesn't give any guidance on that point. And so that's why the Supreme Court has always said unbridled discrimination is unconstitutional.
Mr. Baca, we want to allow you to air your views, but we're already well over time. So, and I think you've made that point very clearly before.
Thank you.
Any other questions from the panel?
No, I appreciate that, Mr. Baca, and I appreciate that, Judge Hartz.
Thank you, Your Honor.
Thank you, Mr. Baca. Mr. Tucker?
Oh, you're on mute.
You're on mute, Mr. Tucker. We haven't heard a word you said.
We haven't disagreed with anything you said.
Mr. Tucker, you're muted.
There you go.
My apologies.
Okay.
My name is Alex Tucker, and I represent Secretary Oliver along with my colleague Larry Marcus on the brief. May it please the court.
Let me start by getting some background straight, because this statute talks about payments by campaign committees or candidates. So apparently in New Mexico, a candidate doesn't have to have a campaign committee to receive political contributions. They can be made just directly to the candidate. Am I correct about that? Or is there something I'm missing in the law?
I'm not sure about that, Your Honor. Typically, a candidate collects and spends funds through a campaign committee. And if we look at the definitions in 11926, the campaign committee typically is always making expenditures towards the actual campaign operations and political speech.
But it doesn't, the statute does not seem to restrict itself in these requirements we're talking about to campaign committees. It says candidate or campaign committee, does it not? And so I was just wondering how that worked. How can you tell when somebody gives money to a candidate, whether that's a personal gift? See, it says it is unlawful for a candidate or the candidate's agent to make an expenditure of contributions received, except for the following purposes or as otherwise provided in this section. So if a candidate can accept political donations, how do you know when that candidate spends money, whether that's money that was made as a campaign contribution, or maybe if the senator is known for being generous with students who want to go to law school or whatever, that I'll contribute to that for the senator. I'm not interested in his campaign. How do we distinguish that? Or am I missing something and every candidate has to have a campaign committee through which the contributions are funded?
Your Honor, I'm actually not familiar enough with the statute to touch on that issue, considering that this is a facial challenge only to subsection A4 of 11929.1. I would be happy to offer additional briefing to the extent that would assist the court, but I did want to focus on why—
I realize that's a little outside, it is outside the specifics of this case, but it makes it very difficult for me to analyze this. If a candidate can't make a contribution to help someone go to college, but the candidate doesn't have a campaign committee, so the money just is going to the candidate, and the candidate can't distinguish between what's a gift to the candidate for use for anything, or it's a campaign contribution that's restricted by this law. If the parties could give some guidance on that, I would find that relevant and perhaps helpful.
Thank you, Your Honor. I'm not sure I can provide that right now on the spot.
No. 28J letters are fine. Do that within a week, though, right? Do it before Thanksgiving. We'll give you till Wednesday before Thanksgiving. Is that enough time?
Yes, sir.
Mr. Baca?
Your Honor, I'm flying out this afternoon for Thanksgiving. Could we extend it to the first week of December 1st?
If you're not happy with what Mr. Tucker provides, then yeah, let us know by then, okay?
Okay, thank you, Your Honor.
Okay, now we're ready to, you can start with the argument you were planning to make, Mr. Tucker.
Thank you, Your Honor. I want to remind the court first that at issue today is only a First Amendment facial challenge, specifically to subsection A4 of section 1-19-29.1 of New Mexico's Campaign Reporting Act. And I'm going to refer to that statute as New Mexico's personal use statute, because the purpose and function of this statute is not to regulate speech or things that would actually be considered legitimate campaign expenditures protected by the First Amendment, but the types of improper use of campaign funds for non-campaign purposes that do not necessarily create a message or further political messaging or operation of an actual campaign. The district court recognized as much in granting summary judgment to Secretary Oliver. This court should affirm for two reasons. The first is because plaintiff does not have standing to bring his facial challenge. The second reason is because his facial challenge fails on the merits. And I'll start with standing. And I'm going to go a little bit out of order because I think redressability is really the fatal flaw here, but there's also some issues with injury in fact, but I'll start with redressability. The plaintiff's case functions on a fundamental misreading of subsection A4. Instead of reading the statute as a whole and in relation to its other parts, plaintiff reads subsection A4 as creating a de facto ban on any and all campaign expenditures to 501c4 organizations. Accordingly, in his complaint, the relief he seeks is a declaration providing that only subsection A4 violates the First Amendment of the Constitution, as well as a permanent injunction enjoining the state from ever enforcing subsection A4. But the senator has misunderstood that A4 creates a de facto ban on donations to 501c4 organizations. If an expenditure would further the operations or messaging of the campaign, of course, that wades into political speech and will be allowed under other subsections of the statute. Again, if you read A4 in a vacuum, sure, you might be able to construe it the way my colleague does, but that's not what case law tells us to do. In a facial challenge, we have to first look at a statute to see how it operates. And part of that is following basic canons of construction that provide that we need to read a statute in relation to its other parts. And so any expenditure to a 501c4 that would legitimately further a campaign and therefore be covered by the First Amendment is usually going to fall under subsection A1. And that's
only if we subscribe to the district court's interpretation of A1, right?
Sorry, Your Honor, I missed the first part.
That's only if we subscribe to the district court's interpretation of A1, which is a merits-based inquiry, right?
The district court's interpretation, A1, Your Honor, is a reasonable interpretation that case law instructs courts to reach.
I understand that, but I thought you were addressing standing instead of the merits of his First Amendment claim.
I'm getting there, Your Honor. The redressability issue arises from this misunderstanding of the statute. A4 by itself just creates a presumption of legality for money going from a campaign account to a 501c3. And so if this court gives plaintiff everything he wants, and that's a declaration that A4 is invalid and unenforceable, all that would do is just remove the presumption of legality for expenditures to 501c3 organizations, which would not
push back on that. Okay, sorry to talk over you, but because you made that argument in your brief very well, and I understand that. But the plaintiff in the senator in his complaint also asks in his prayer for any other such relief as he may be entitled to under Rule 54C. And Rule 54C says every other final judgment should grant the relief to which each party is entitled, even if the party has not demanded that relief in its pleadings. So I do understand, and even if we credit your argument that the relief requested to eliminate A4, would not redress his injury, the substance of his claim is that the prescription of these expenditures, which is the entirety of the provision, should be invalidated as a violation of the First Amendment. Is that fair?
I don't think that's fair, Your Honor. I think in plaintiff's brief itself, he actually emphasized that the challenge is only to subsection A4. And I think if we observe traditional principles of judicial restraint when weighing facial challenges to state statutes, the considerations of severability and basically only touching the statute to the extent absolutely necessary to render it constitutional would apply here. And so to the extent the court would be looking at any further relief than what plaintiff has asked for, I think, one, there's a problem because there hasn't been meaningful record or argument developed as to those issues. And two, he just simply hasn't met any burden to show that A4, let alone larger parts of New Mexico's personal use statute or larger parts of the Campaign Reporting Act have more unconstitutional applications than not. And that's his burden in a facial challenge. So just to recap redressability, once again, the purported injury is that the senator wants to spend money left in his campaign accounts, perhaps to individuals, perhaps to 501c4s. Eliminating A4 would not have the effect of allowing him to do that because the statute, when properly read as a whole and in relation to other parts of the Campaign Reporting Act, targets conduct, not speech. It encompasses and allows anything that would be allowed anything that would constitute First Amendment protected.
So you're saying if a statute prohibits conduct, then there's no First Amendment interest to be addressed? I mean, even in O'Brien, where the Supreme Court upheld the ban on burning draft cards, the court acknowledged there was an expressive element to it and had a way of reviewing whether such bans on conduct can survive First Amendment review. They didn't say that because it's conduct, burning a draft card, that therefore it can't be speech. I mean, the Supreme Court said you can't ban flag burning, for example. I'm sure you're familiar with that case. So
yes,
why
sir.
do you say this is just conduct when some of it can be expressive conduct? In fact, a lot of it would be, yeah.
Yes, well, maybe I shouldn't have painted so broadly, Your Honor. What we're saying is that gifts to individuals that aren't directly related to campaign purposes have very little expressive conduct. And I understand that Your Honor's acknowledged that in the questioning to my colleague. But
there's some.
There may be some, but even though there may be some, we have examples where there is very little expressive value and the state has a serious interest in preventing self-dealing or other quid pro quo uses or improper uses of campaign funds, that these types of statutes, even if they operate to regulate in some instances the fringe of constitutional speech, they're still assessed under rational basis review. And that's the O'Donnell case out of the District of Delaware, which is one of the only cases in federal law where we're dealing with at least somewhat on point analogy to a facial challenge to a personal use statute. The other cases that plaintiffs rely on are in the category of cases that I would call hard limit or hard amount cases, where the reasoning of Buckley kicks in, because when you limit the amount of money that a campaign can spend, you are necessarily limiting any speech that would proliferate as a consequence of spending that money on additional campaign operations. But this speaks to the larger purpose of New Mexico's personal use statutes and personal use statutes across almost all 50 states and in federal law, is that they don't target and are not intended to target actual protected political speech. They're intended to target conduct that is not protected by the First Amendment, and that is the use of campaign funds for matters that are not campaign uses and do not necessarily further any sort of political speech. Spending money by itself isn't speech, particularly in the campaign context, unless you get into the money being used to further the operations and messaging of a political campaign. Then it's speech. But
you're saying the only type of speech that counts is political speech? If a contribution is speech or has a speech component because it advances your political cause, then why is it not speech if your contribution advances some other cause that's not political?
Well, it may or it may not. And the court doesn't have to engage in that speech line drawing to actually affirm the district court. Because if we look at New Mexico's statute, just because the statute allows certain expenditures does not mean that those expenditures would also necessarily enjoy First Amendment protection. It just means that New Mexico chooses to allow them. But anything that would enjoy First Amendment protection, including certain expenditures to 501c4 organizations, would typically be encompassed under other subsections of New Mexico's personal use statute and not necessarily subsection A4.
Let's get to specifics. One thing Mr. Baca focused on is, under your analysis, the Secretary of State can make a decision that providing campaign funds to help someone get an abortion is protected. It's not prohibited by the statute. But using campaign funds to help someone go to law school is not protected. Is he characterizing correctly what the Secretary of State's position is?
He is not, Your Honor.
What's his error?
The problem is that, so if we go to the abortion hypothetical, in that hypothetical, the Secretary considered it an expenditure of the campaign because, and if we look at the district court's discussion of that hypothetical, the donation itself carried with it significant indicia of speech and support of the campaign and the political message of the candidate. And
okay,
again,
so why does that not also apply to the expenditure to allow to help this woman go to law school? Why is that different from the expenditure to help this person go to law school? Doesn't that convey a strong support for higher education?
Not in and of itself, Your Honor. The only indication in the record.
So the Secretary of State has that authority to decide, well, I don't think that expenditure, the expressive aspect of that expenditure is protected, but this other expenditure, expressive component, is protected. You're really going to let the Secretary of State decide those things?
And she's not necessarily deciding what is and isn't speech, Your Honor. Neither the statute nor the Secretary decides what's protected by the First Amendment.
Well, let me focus that. Did she distinguish between the two types of expenditures? Money going for an abortion and money going to help someone go to law school? Did she make a distinction between those two, and one's prohibited and one's allowed?
So
whatever her reasoning, did she make that distinction? She might have had a good reason, but did she make that distinction?
The distinction was based on the level.
No, I'm not interested in her reasoning behind it. We can get to that later. Did she say this one is allowed and this one is not? Did she reach that conclusion?
She said that under her interpretation of the statute and the regulations she promulgated, because it carried the indicia of political speech with it.
You're not answering my question. I just said, don't give me her reasoning. I want to know her bottom line. Was her bottom line that the money to help this woman go to college or law school was prohibited by the statute, but money to help somebody get an abortion was allowed under the statute? Was that her bottom line? Yes or no?
No, Your Honor.
It was. Okay, so she said, then why did she, what was the difference? What was the difference? Did she did say that the money going to help this woman go to law school is permitted under the statute. That's what you're saying. She made a decision that Senator Ortiz Pino could use campaign funds to help this woman go to law school, college, whatever it was. She said that's okay?
She did not say that was okay, but nor did she decide that it necessarily violated the statute. All she did, and all she can do, is refer for prosecution. And the reason
but she wouldn't refer for prosecution an expenditure to help someone get an abortion. Is that correct?
In the specific circumstance raised before the district court, where that donation to the student to get an abortion carried with it significant public political speech, that was the difference maker there. And although the circumstances of the $200 donation at issue in the senator's as applied case, that's not before this court. This court is dealing with a facial challenge. But just for the sake of argument, we can go back and look at the record, and nothing about this donation actually showed any expressive value. It was a gift to an individual that by itself had very little disclosure in
that's true of any contribution. Every contribution is a gift, and the expressive content is, by giving this money, do I show support for this cause? And in one case, you support the cause of abortion. In the other, you support or choice. In the other, you support the cause of letting indigent or less well-off people get higher education. What's the difference in the expressive content in the two? Except that she might approve of one and not the other.
The difference, Your Honor, again, if we go, so I guess, how can I frame this? To save the statute, we don't need to do any line drawing there or look at that hypothetical to save the statute from constitutionality, because even this gift to the student itself, it might not, the abortion gift might not have First Amendment protection, but that doesn't mean that New Mexico's Campaign Reporting Act can't allow it, and that the secretary can't promulgate and reasonably interpret the statute to understand that gifts that carry with it the indicia of political speech.
That doesn't scare you at all? That a state official can decide, I think that speech is important and that speech isn't. And
well, she's not deciding
to prosecution in one case, but not the other. That doesn't disturb you as being fundamentally contrary to First Amendment principles?
Well, Your Honor, this is not unbridled discretion we're talking about. The regulations and what the district court recognized as a reasonable construction of New Mexico's personal use rules is built into the plain language of the statute, and not just 11929.1 said together, but also in the definitions of 11926. The secretary, those regulations and that interpretation that it carries with it the indicia of speech acknowledges that the expenditure has a political purpose. And that's in 11926. We have subsection W, subsection F, subsection G, and probably most importantly, subsection P for the purpose of applying A1 of 11929.1. And subsection P defines an expenditure. And A1 of the personal use rule allows all expenditures of the campaign. But the important part of the definition of expenditure is that it must always have a political purpose. And so we can tell that something has a political purpose when a candidate shows that they're giving expressive value, particularly in the context of their campaign, uses of campaign money to further the messaging and operations of the campaign. So we can tell that in the abortion example because that example had carried with it a measure of publication, a measure of expressive support. Whereas if we look at the actual record of the senator's donation, he in no way publicly made this donation. This was a quiet $200 gift to an individual labeled with a very nondescript charitable donation to scholarship or something along those lines. And so it's very difficult for us to achieve the purposes of a prophylactic statute like 11929.1 without flagging donations like that and at least digging a little deeper. And with respect,
I think you made your point. We're way over time, so I'd like to make sure my colleagues have a chance to ask any questions they have.
No, thank you, Judge.
None for me.
Okay. I think that does it then. Thank you, Mr. Tucker. Did Mr. Baca have any time remaining?
Mr. Baca was 8 minutes over as well.
Okay. Oh, okay. So it worked out very evenly. You each got 23 minutes, so that's good. Even if we were fair inadvertently, at least it ended up being fair. Okay. Thank you very much, counsel. Case is submitted. Counsel are excused. Have a good vacation, Mr. Baca. And
thank you, Your Honor. So there will be an AJ letter, 28J letter.
I'd like a 28J letter from Mr. Tucker for Thanksgiving by next Wednesday, a week from Wednesday.
Yes, Your Honor.
That may be all we need. I'm just curious what the law is about candidates raising money without a campaign committee.
So the question, Your Honor, just to clarify, is under the Campaign Reporting Act, can candidates raise money without a campaign committee?
Yeah, it's because of the language in 11929.1a. It is unlawful for a candidate or the candidate's agent to make an expenditure of contributions received. That may mean candidate make an expenditure out of the campaign committee funds. I'm not sure what it's referring to, but I couldn't find anything, and I will have missed something, that requires candidates to have a campaign committee to accept the donations and make expenditures.
Great, thank you, Your Honor.
Thank you. Very good. Case is submitted. Counselor excused. We'll be in recess until 9 a.m. tomorrow morning.
Thank you, Your Honor.
Thank you.